9 session. Pursuant to adjournment, United States Constitution is on the court.
Good afternoon and welcome to what might be the last virtual oral argument in the First Court of Appeals. We'll see what the next few months bring us. We only have one case on today's docket. Case number 0120000194CR, Joshua Pierce Schneiser versus State of Texas. Can I have the appearance of counsel for the appellant, please?
Yes, Mike Diaz for the appellant.
And for the appellee?
Yes, Kyle Jones for the State of Texas.
And Mr. Diaz, are you going to reserve time for rebuttal?
Yes, sir. I asked for 5 minutes, Judge.
Okay, and I think the staff operating the timers has reflected that by giving you 10 minutes to start.
Yes, sir.
So, Mr. Diaz, whenever you are ready.
Yes, Judge. I believe that the trial court abused its discretion by allowing photographs of the accident and Adam Arsenal's body in this case. I believe that it was harmful. It affected the substantial rights of Mr. Schneiser, the appellant. Let me remind this court that Mr. Schneiser was charged with aggravated assault with a deadly weapon. So the state introduced evidence, photographs specifically of the roadside accident where Mr. Arsenal was run over by 2 different vehicles. In addition to that, they showed photos of his body. I think one specifically of his body. And Mr. Kendall, trial counsel objected to that. He had a motion to limine, which although doesn't preserve it, but in the course of trial, he objected once the state introduced those photographs of Mr. Arsenal regarding the accident and his body.
Just to be clear, the point on appeal solely relates to the admission of the photographs, not other testimony relating to what happened afterwards.
Well, I believe the point of error includes testimony as well as the photographs, but specifically the photographs, I think, that were offered in to evidence. Were objections to the testimony properly preserved as a separate and apart from objections to the photographs? The testimony, there was some testimony that wasn't preserved as regarding the testimony, but as to the photographs, yes, sir, there was. Yeah. So that is why we're here. I believe it was harmful. If you look at the entire record in this case, the state had 8 of their 14 witnesses that focused on the accident, the death of Adam Arsenal. In addition to that, Mr. Golden, the prosecutor's closing, focused on that, and you can't say that didn't have a substantial effect upon the jury in this case.
Well, how did he focus on that?
Well, in his closing argument, 8 of the 14 witnesses that they called to testify, there was substantial testimony regarding solely the death, the accident of that. That's 1. 2, in his closing, he mentioned the fact that he's about the death of Adam Arsenal, but for being there because he died. So if you look at the entire record, that's the harm shown to Mr. Schneiser.
Okay, assuming without holding from the bench that objections were not preserved with regard to the testimony, but they were preserved with regard to the photographs. Could you focus your argument solely on the admission of the photographs? And specifically, what use was made of the photographs in closing argument?
Okay. Well, as far as the photographs are concerned, States Exhibit 1, 2 through 9, 12 through 15, Mr. Kendall timely objected to those. They showed those to the jury. The jury was aware of it. I believe it's one thing to talk about it versus actually showing these pictures, the prejudicial nature of these pictures, these photos of somebody laying on the roadside, dead. He's been run over. Furthermore, they're showing pieces of his body tissue on the concrete, the highway. that has an influence upon the jury.
Mr. Diaz,
Yeah.
what is your best case for why the pictures are different? If I understand your argument, it's that the state was free to tell the story of how he was ultimately killed, but showing the pictures was a bridge too far. What is kind of the best authority that you've got for that point?
Well, factors regarding admissibility, according to Prival v. State 175 Southwest 3D 724 Texas Court of Criminal Appeals, the number, size of photographs, whether they in color or black and white, whether they are gruesome, that's one factor, as in this case, they are very gruesome. Again, the indictment had nothing to do with his death. To the state's need for these photographs. So I don't know why they needed these photographs to prove up an aggravated assault with a deadly weapon. Their focus was on the death, not the actual indictment.
So, Mr. Diaz, what do you make of their argument that the photos showed sort of a continuous course of events, or that the photos also showed some, blood droplets that appeared to be prior to any vehicles hitting the victim?
Well, the blood droplets could be from anything, Judge. They could be from him hitting the ground when he fell out of the truck. We don't know how he fell out of the truck, but when he hit the ground, the blood droplets. So the medical examiner could not conclusively say that he had any type of wounds on him. There was no stab wounds. The medical examiner could not say he observed any type of stab wounds, although it was an external autopsy. But so that's the issue. There was nothing.
Was that what the examiner said? Did the examiner say there were no stab wounds, or did the examiner say they didn't look for stab wounds, but the wounds could be consistent with it?
Well, Judge, I believe on cross-examination, Mr. Kendall asked me, you couldn't say this, couldn't see any stab wounds, and the medical examiner couldn't say he did. So,
but they only did an external autopsy and not an internal autopsy, correct?
Right, because the JP ordered that, yes, sir.
And were they looking for stab wounds, or were they just looking to determine that it was an accidental death?
I think that they were, according to the external autopsy, they observed the whole body, and the doctor could not say, yeah, I saw stab wounds on there, because otherwise it would have been reported in the autopsy summary, there wasn't any mention of that. Other than money on cross-examination, when Mr. Kendall asked him, he couldn't say there were stab wounds. So going back to Justice Guerra's question about whether or not those droplets, they could have come from anything. It's pure speculation as how they ended up there. But we know he hit the ground at some point in time. He was run over. He was dragged possibly. So the blood droplets could have come from that. But after that, as far as his death is concerned, as far as any type of photographs related to a dead body on the highway, that has no purpose with the state's case. They didn't need any type of evidence. That prejudiced the jury. It inflamed the jury seeing those pictures. And again, it had a substantial effect on the appellant's rights in this case.
Well, wouldn't it go some way to explain why there was a 3-week delay between the incident and sort of the turning of the investigation into an investigation of an intentional assault, and would explain things like perhaps the knife was discarded, perhaps the clothes were washed, and wouldn't that explain how the investigation unfolded, the state's investigation?
I don't think it has any bearing on that, Judge. With all due respect, I think this talking about the death has nothing to do, again, with whether or not he was threatened with a knife inside the truck. That's pure speculation. But as far as these photos are concerned, that leaves a lasting impression upon a jury on an aggravated assault case. The fact that he's dead lying in the roadway.
But don't you also, forgive me, don't you also agree that there was evidence there that, he admitted possessing a knife, he admitted taking it out, there was a slash mark on the car. what do you say about the sufficiency of the evidence?
Well, that was my second argument, Judge. The sufficiency of the evidence. We don't know, according to the case law I put in the brief, there was no evidence whether or not he lunged. Usman never saw a knife. Usman never saw him threaten him, although the defendant himself admitted to, I believe, Terry or White, one of the detectives, he held a knife there, never swung it, never slashed it. And the case, there was not enough description about that pocket knife. So we can't say it's not a deadly weapon per se. We don't have any description regarding any type of knife in this case. And if you believe Schneiser, then you believe that he just held the arsenal at bay. If you come back over the seat, I'll use a knife. If you don't, then, there's no issue. So without more facts or without more evidence regarding what took place in that truck, it's pure speculation. And that's what the state's case is based upon.
It's not pure speculation if Mr. Schneiser says, I got out a knife. And then he says, it's not a direct explicit threat, but it's certainly an implicit threat to show him that the argument was over. And that implies a big or else. Do we need anything more than that to find that the evidence is sufficient?
I believe you need more, yes, sir, on the knife itself, how it was used, the manner and means of how it was used. Just saying, yes, Schneiser had a little pocket knife, isn't enough to say that.
But he admits that he got it out to show that the argument was over. And what does he mean by that? That if you start the argument again, I'm going to cut you, right? That seems like a threat.
Well, that's all there is. So we can't read into that. Otherwise, we're speculating. And again, like I'm saying, we're guessing. And a juror's role isn't based upon speculation. It's not a guessing game. So all you have is him pulling out a knife. We don't know where.
Well, him pulling out his knife with the intent to show that the argument is over. Now, the jury can hear that testimony, and I think it's a reasonable conclusion from that, a reasonable inference that there was a threat there to use the knife in a dangerous manner.
I think if anything, it was in response. If you believe that, then you have to believe Adam Arsenal held him in a chokehold. And again, Schneiser, if he was defending himself, we don't know any more facts after that. He pulls out a knife and that's it. We don't know. You can't infer that he held it to his throat or stabbed him based upon the testimony or lack of testimony, I should say, in this case. That's why I'm suggesting that the state's case is nothing but pure speculation as to what happened in that truck. Can a person defend himself with a little pocket knife? I suppose so. If, he's in the front seat, the alleged victim complainant's in the back seat, but that's not enough to show any type of threat or, stab wounds to Arsenal.
Okay, Mr. Diaz, we have your argument. If there are any further questions from the panel? No, thank you. Then Mr. Jones, you may proceed with your response.
Yes, Your Honor. May it please the court. I want to start with that last point first, and I'm in agreement with what you brought up there, Justice Kelly, with regard to the jury's role here, because what we had at trial was essentially a confession and avoidance strategy. We have a self-defense instruction because the defendant admitted to the conduct. However, he claimed that he pulled the knife and threatened with the knife because that was in self-defense in one of his statements after he eventually said that's what happened. There were other statements he made prior to that. And the jury, in its role as fact finder, was free to reject his testimony that he did this in self-defense and find that he pulled that knife as a threat, that he brandished the knife towards Adam Arsenal based on the defendant's admission, as well as some other evidence that I'm going to talk about in a second. But I do want to address the point that Mr. Diaz focused on for the majority of his oral argument, which was the photographs in this case. I think there's been a concession here that general testimonial evidence regarding the death of Adam Arsenal was not preserved at trial. And I think if that was suggested by the court, I would certainly agree with that. Even though it was brought up orally during a motion in limine prior to trial, that does not preserve that error. It was incumbent upon defense counsel to raise that objection at trial when that testimonial evidence came in. Not only was it not raised with any of the investigating officers, with the detectives, with the medical examiner, but he actually talked to the defense attorney, talked about.
Let's talk about the pictures. What purpose did they serve?
What purpose did what serve, Your Honor?
The pictures.
The pictures.
What element did they buttress?
Here we're talking, and I think defense counsel was just talking about the sufficiency of the evidence with regard to deadly weapon. And I think that's key here when we talk about why these photos were relevant. And we're talking about distinct things here between relevance and Rule 403. So first, as far as relevance is concerned, I cited to Cunningham, which is a 1998 case out of the Court of Appeals, published case out of San Antonio, that talks about same transaction contextual evidence. And in that case, very similarly to this one, you had an aggravated assault by threat where a park ranger pursuing suspects fell into a creek and died as a result. And the defendant in that case stated that, they shouldn't be able to get into the death of the park ranger, that it was extraneous to the conduct. But what the court determined there was, hey, if we're going to talk about the context of this criminal action, it just doesn't stop and we forget about the fact that someone died. This was contextual to what happened that day. Same transaction, contextual evidence. And not only that, but there was testimony, I think from the park ranger going back to dispatch in that case. So there were messages from the park ranger. And so the jury needed to know, hey, if we're getting messages from this park ranger, why isn't he coming up here and testifying? And so getting into the death of Adam Arsenault accomplishes both of those things. It's same transaction, contextual evidence. It explains to the jury why he's not present. As far as the photographs themselves, deadly weapon is something that has been brought up as far as sufficiency. There was an officer that testified, and the photographs show this at the scene, that when you have a car that hits someone, you would expect viscera and blood to be sent backwards. But that wasn't the only type of blood droplets that he saw at the scene. He saw what he called gravity-fed droplets, or low-velocity droplets that indicated that Adam Arsenault was bleeding prior to being struck by the vehicle. And so I think the inference that the jury could have made from that evidence certainly is that he was wounded prior to falling out or jumping out of the Toyota Tundra, and that those low-velocity droplets needed to be shown to the jury so that they could understand that there were wounds, because otherwise.
What about the autopsy photos, though? I mean, there's one photo where, I believe it's of his face, and it's very clear he's suffered an extremely gruesome, kind of head wound. I believe they said like the brain was almost obliterated. Say we buy the scene of the accident, but what is the purpose of that autopsy photo?
I think that's a fair point, Your Honor. I think in this case, what we're talking about is to show the nature of what occurred at the scene and the type of damage that the body underwent. And I don't think they showed more than, I can't remember the exact number of photos. There were not more than 12 total, I think, that were objected to. But as far as the autopsy photos, you have to understand, I think, the nature, the gravity of the injuries suffered by these vehicles striking Adam Arsenault, because Yoshiyuki Kikuchi, the medical examiner in this case, was not able to testify to knife wounds. And so the jury had to both understand from his testimony and seeing in the photographs of why they were unable to detect knife wounds when he was not asked to do the internal autopsy that may have revealed further knife wounds. And the reason he did not see any of those was because of the severe nature of being first struck by the initial vehicle and then being carried under the undercarriage of the second vehicle. So those extreme injuries would have prevented him from being able to tell that there were knife wounds that would have gone to have shown that a deadly weapon was used in this case, which was one of the contested elements, certainly, that Appellant has raised on appeal. Was there enough, when the knife is not a per se deadly weapon, obviously, is there enough evidence to show that it was a deadly weapon? And I think that those wounds, even though this is an aggravated assault by threat case, the evidence of wounds would go to show that the knife was capable of inflicting serious bodily injury or death and was therefore a deadly weapon. I think even if we assume that one photograph was potentially harmful, I don't think there's really been a showing here of any harm under a non-constitutional standard under 44.2a. I think there's case law out there saying even if there's admission of gruesome photographs, this is not going to require reversal. There was a limited number of photographs here. Even if you're looking at it from a 404 perspective, or I'm sorry, a 401 or a 403 perspective. You've got a situation where you have a limited number of photographs. There's no internal autopsy. There's no manipulation of the inside of the body. And I know the face itself, obviously, a terrible thing to have to look at, but nothing more than the natural consequences of what happened that day as a result of the appellant's actions. And
well, but sorry, was that really the natural consequence of his actions? I mean, to me, there is somewhat of a separation. I mean, if you're in the car with someone, and let's just assume that he brandished the knife, would someone assume that the person is going to jump out of the vehicle and then get hit by other vehicles and die as a result?
I think that is potentially foreseeable, though I don't think that's really, I'm not sure if that's exactly the issue that is raised as far as foreseeability. But I think also there was evidence that it was more than simply brandishing the knife within the vehicle, Your Honor, Justice Guerra. I believe we also had evidence, and I was going to get into this as far as sufficiency with the deadly weapon that I can turn to now. We had circumstantial evidence of wounds, not just the gravity-fed droplets at the scene, but within the vehicle. There were blood droplets where Adam Arsenault was seated, that his DNA could not be excluded from those blood droplets. We also had a knife mark, a knife cut in the center console, showing that the knife may not only have been brandished and used as a threat, but that there may have been further than that. There may have been cutting of the center console and then potentially wounds inflicted upon Adam Arsenault. And so I think when you're brandishing a knife in a car, cutting the center console, and then potentially causing wounds in the victim in a case like this, it could be foreseeable that that victim would do anything possible to get out of the vehicle, to get away from the imminent threat, which is the man who's wielding this knife. So, though I certainly can see your point as far as a potential disconnect there. In addition, as I think Justice Kelly stated earlier, we have the appellant's admissions to brandishing that knife, and that the jury could certainly have rejected the self-defense claim and found that he threatened Adam Arsenault with the knife. And that the jury could have made an inference at that point. If you're going to threaten someone with a knife, you're not going to do that unless that knife is capable of inflicting bodily injury, serious bodily injury, and therefore is potentially a deadly weapon. Also in this case, as far as sufficiency of the deadly weapon, there were hypothetical questions that were asked by the officer that I think were relevant. And in fact, one of appellant cited cases, Davidson talks about the fact that there were no hypothetical questions to experts in regard to the sufficiency of the knife as a deadly weapon in that case. Well, here we have two important questions to Detective Lewis, whether you would use a knife to protect yourself from supposed deadly force unless it was a deadly weapon. And Lewis responded, well, no, you wouldn't use the knife unless it itself was capable of causing serious bodily injury. It would need to be a deadly weapon. Otherwise, why would you use it to defend yourself? An inference the jury could have made, but also some testimony there to reinforce that. He was also asked what could have caused that cut in the center console of the vehicle. And he responded, well, it could have been certainly a small knife, and it could have been something small and jagged, which is similar to the pocket knife that defendant admitted to using. So I also think there's a reasonable inference to be made, as we discussed earlier, Justice Guerra, regarding the potential for this knife being a deadly weapon and what actually caused Adam Arsenault to jump from the Toyota Tundra. Because appellant suggested in his earlier, or I think the phone conversation, I can't remember if it was just earlier in his oral statement, that Adam Arsenault just decided to leap from the vehicle, that he bailed out. And later he had to admit, well, maybe he jumped out of the vehicle because a knife had been pulled. Well, there's an inference there. If he's jumping out of the vehicle to get away from the knife, that the knife could potentially be a deadly weapon. There's a litany of circumstances of guilt in this case that I think further reinforce the guilt of the defendant, the jury's finding, The classic oldie returns to the scene of the crime. He leaves the scene without calling 911, talking to law enforcement, attempting to find some sort of medical personnel to help Adam Arsenault. We've got, I think, all three of inconsistent statements, implausible explanations, and concealment of evidence. Inconsistent statements: did not initially admit that he had the knife, later admitted, yeah, I pulled the knife. And I used
what's your best case for going back to the inference that it is a deadly weapon? What is your best case, the best authority for the proposition that sort of reactions to the weapon can establish whether the weapon was deadly or not, or assumed reactions. That the jumping out of the car means that the knife that was witnessed inside the car was indeed deadly. Are there any cases addressing that point?
I'm not remembering off the top of my head, Your Honor, the case that I cited for that. I know there was a case, it wasn't a direct analogous sufficiency issue where someone had leapt out of a vehicle and they found that that supported an inference. I can't remember if it was of a deadly weapon but that some kind of flight from the vehicle supported that. I would have to go back and look in my brief. I'm not remembering off the top of my head.
And what about case law that supports that other proposition that if you're going to, display an item, that the only reason you're going to do so is because you believe yourself in displaying it or brandishing it, that it is a deadly weapon?
I think, Your Honor, I would point to Robinson, Court of Criminal Appeals case from 1980, and then this court's case in Mitchell, and a quote that I had just written down. The display of a deadly weapon within itself constitutes a threat of the required imminent harm. I'm not sure if there's just an inference to be taken from that this deadly weapon, just because there's an inference that potentially when you're defending yourself that you need the deadly weapon. I'm not sure if that is directly applicable, and I may be coming up short in terms of giving you the case that you're asking for here. But I do think even without case law that there's an inference to be drawn from that, not just what the jury could have decided that he would have used this in response to deadly force, alleged deadly force, and that it was more than likely a deadly weapon, but also the officer's testimony with a hypothetical question that was talked about in Davidson. It essentially said, if he's using this, then more than likely, yes, it's a deadly weapon, because why else would you do it? I do want to talk briefly about legal sufficiency of the threat. I don't think there were any cases cited in the appellant's brief regarding that, but I did want to bring up Olivas, 2006 Court of Criminal Appeals case that talked about two things that you needed, essentially. You needed perception of threat of imminent bodily injury, and you needed use of a deadly weapon. In that case, it was a firearm. And that it seemed from the court's opinion that they did not necessarily need to be contemporaneous. You just needed some evidence regarding perception of threat of imminent bodily injury in addition to the deadly weapon. So I think we've shown through the evidence cited earlier that we have here a deadly weapon, but I think there's a number of places where you could have perception of that threat. I think through the testimony of Muhammad Usman said that appellant related threatening words to Adam Arsenal, that he told him to shut the F up or I will beat you at one point, and that he said that appellant threatened to kill Adam Arsenal. And then in addition to that, we have the text messages from Adam Arsenal to his ex-girlfriend that showed this perception of some kind of threat because he was concerned, he was scared for his life. He said that
let's return to the photographs real quick,
yes, sir.
Which is, assume that we find that the transaction ends when Mr. Arsenault flees the vehicle, jumps out of the vehicle. And we say it's erroneous for them to admit it. Then we have to go to a harm analysis. What is your best argument for why these photos, which you more or less concede are gruesome, were not harmful?
Your Honor, I would say it's cumulative of other evidence. That there was no proper objection that was made to testimonial evidence regarding the autopsy or Mr. Arsenault's body at the scene. It's cumulative of the evidence that was admitted that was not properly preserved or objected to at trial. And because it's cumulative of other evidence.
But isn't the shock value of, that's one reason we have this rule, right? Is the shock value of photos can be substantially more than just an oral recounting of what happened.
I would say also that in a situation where you're talking about, and I think really if I've conceded anything, would be that that one photo of the head was certainly gruesome, though I think it naturally flowed from what happened. But I think there's case law that says just because photos are found to be gruesome does not mean that you predicate reversal under a 44.2b standard, because it won't be relating to someone's substantial rights. It won't be impacting their substantial rights just to have a couple of photos that potentially are gruesome. That is not sufficient to overturn the jury's verdict based on harm analysis, Your Honor.
Okay, thank you very much, Mr. Jones. Any further questions from the panel? All right, thank you. We'll go back to Mr. Diaz then.
Yes, Judge, just briefly on rebuttal, the case that Mr. Jones talked about, Cunningham v. State, where the park ranger chased 5 men, including the defendant, and he fell into a creek and drowned. We don't know. He didn't tell this court whether or not any photos were offered or admitted into evidence during that trial. But the fact is, 13 photographs of Mr. Arsenal surrounding the death and the accident were admitted over objection into evidence in Mr. Schneider's case. Again, the body it's gruesome. State didn't need this testimony, didn't need these photographs. Talking about it, as you pointed out, is one thing, but showing photos to inflame the jury where they can see it, something concrete, is totally different. That's a higher standard. Talking about it, letting them know, okay, Mr. Arsenal is not going to be here. This is how he died. That's it. The state kept going and going and going. And it turned out that focus was on the death of Adam Arsenal.
I think Justice Guerra had a question for you.
Yes, I
Yes.
do.
Yes,
And so do you think that the state emphasized the photos in their closing argument as well?
absolutely, Judge. I believe that they talked about it even in their opening. They focused on it with 8 of 14 witnesses solely on the death, the accident of how Adam Arsenal died. And then on closing, Mr. Golden, the prosecutor for the state, went into it even more. So yes, I believe that was the error. That was a harm. That was a harm it caused Mr. Schneider in this case. And again, why did they need that? What's the point of having that, brought out before the jury? Looking back at the indictment, that's not contextual in nature. I've heard the justices say, well, where do we end?
All right,
Where do we end?
let's talk, Mr. Diaz, let's talk about harm for a second. So assume that we agree, same question that I had for Mr. Jones, but the reverse, right? Assume we agree the transaction ended when Mr. Arsenault leapt out of the car and that it was erroneous for those pictures to come in. What harm was caused, and where do you point out that harm in your brief?
I pointed out in the fact that the state's theme, their trial theme, focused on the death of Adam Arsenal and proving this case against Schneider through closing, through the witnesses. That's the harm. The harm is there. It's no one. You got to look at the whole record to show the harm. You can't just look at one thing and say, "Hey, this is the photos themselves are harmful. The opening was harmful. The witness's testimony was harmful. The closing was harmful." You got to look at the totality of the whole trial.
But if the objections weren't made to everything else that discussed the death, then don't you have to have that as well?
Well, again, it's one thing to talk about it, as Justice Kelly brought out, but when you introduce the photographs, again, it's going higher and above and beyond what the state needs at that point. The photo, you talk about it, Adam Arsenal, why isn't he here? Here's what happened. That's it. Touch on it, and then go back to the charge with the Schneider's charge with the state has indicted this defendant with, the appellant with. And then if they go past that, then yeah. But as far as talking about it versus showing pictures, that's a whole different, that's direct evidence of this person's death, the victim's death, which they did not need in this case, Justice Garrett.
Well, here, if we consider the continuous, like the one transaction theory that the state has talked about in its brief, to me, it seems like obviously if you cause someone to jump out of a vehicle, the necessary conclusion is they're very likely to be hit. Jumping out of a moving vehicle, obviously they would sustain some injury when they hit the ground, may not be able to recover in time to get out of the way before a car comes. Would you disagree with that? Or what is your position on that?
Yes and no, Justice Ferris. I believe that the time of day or the night in this case, traffic's light. We don't know, But it's just bad timing, I believe, in this case. You know, two cars happen to come run over him. You know, could it be foreseeable? Yeah, you got to get out of the way, moving traffic, obviously, but even aside from that, I mean, the state is harping upon the death of Adam Arsenal, again showing the photos of his body, and which was not necessary in this case. I mean,
Thank you, Mr. Diaz.
yes, ma'am. Yes, ma'am.
Are there any further questions from the panel? Thank you very much, Mr. Diaz and Mr. Jones. Cause number 0120-00194 CR, Joshua Pierce Schneiser versus State of Texas is submitted. And the First Court of Appeals is adjourned. Thank you very much.
Thank you,
Thank you,
Justices.
Your Honor.